So shall I move on? I am Sanju V K.
Sanju,
Shall I move on?
And another is Sanju Rajan. Sanju Rajan, ma'am, are you there?
Yes, I am here.
Ma'am, please,
Yes.
say a few words. Okay.
Okay. First of all, I like to thank the organizers for inviting me to chair the session and to give a brief idea about my topic with regard to the forum. First of all, I like to congratulate the organizers for bringing within a forum almost all the concerned areas like management, law, human rights, commerce, etc. So, actually being a law student, I try to incorporate or I try to bring a comparison between the human rights and law. And within that itself, what is the implementation of human rights in healthcare? Actually, when I went to the papers which have been forwarded to me, I find out that nobody has touched the healthcare. In my concern, with regard to when I concern about the human rights and its implementation in law, we all know that international human rights law is a very wide area which guarantees everyone the right to the highest attainable standard of healthcare. And for that attainment of healthcare, everyone, including you, me, and the government, has a very key role to play. And on the process of this COVID-19 pandemic area, we know that many of our rights have been curtailed, including our right to healthcare. And we know that we have been brought within the four corners of our house. We have been shifted to quarantine, isolation, which limits our freedom of movement. But at the same time, it also brought so much concern about our health as well as providing us the healthcare facilities. Actually, we know that the right to health is not an area which can be isolated or which can be shifted from other rights. The right to health includes within itself the right to food, right to having nutritious food, right to have a free environment, right to housing, right to work, right to free from torture, right to get privacy, etc. So, under international human rights law, as I already said, government have an obligation to provide to us almost all these rights which are being guaranteed to us as a human right as well as our fundamental right under our Indian Constitution. But even though when we speak about largely about our human rights, our fundamental rights, etc., there are certain sector of people who are not even having knowledge about their rights and dignity. One sector of people is with regard to tribal people. As the latest census report, when we go through the census report, we can find that about 20.2% of the Indian population comes within the tribal people. But whether we, being the citizens of India, we speak largely about our human rights, our freedoms, our dignity, etc., whether we are able to provide these people their basic guaranteed fundamental rights. We have an open case before us with regard to Madhu murder case in Attapadi district, where his rights have been violated when he was in search of his basic right like food. So we have to speak about their human rights rather than speaking about our human rights. So why I am being concerned about this is that there are a group of people within this tribal population, that is women community, that is tribal women, who are being degraded about or who are not having any knowledge about their reproductive rights. We speak about our reproductive autonomy, we speak about our right to get aborted, we speak about our right to have a reproductive choices, etc. But what about their reproductive right when they are not having any basic idea with regard to their basic changes which are being taking place in their body, like menstruation, menopause, abortion, gynec disorders, etc. As we come across, we can find out that the government is not, we cannot say that the government is not implementing any policies and all. Government is implementing policies. When we look upon from the second 5-year plan to the 14th 5-year plans, or when we go into the National Rural Health, 12th 5-year plan, and also when we go into the National Rural Health Mission, etc., the government is promoting funds to these tribal people. But whether this is reaching to them, whether this amount is reaching to those people who are in need of them. So when I go into right to health and when I specify into the right to reproductive autonomy of a tribal women, when I went through the study, I found out that the tribal women are not even aware of their basic right. When we speak about our UDHR right, like Article 16 Clause 1, which says that the right to reproduction is a basic human right. And when we speak about our Article 14, Article 16, Article 21, etc., which are considered to be as a basic fundamental right, which speaks about right to life, right to equality, etc. But these rights are not being guaranteed to the women who belongs to a tribal community. Why I say so? Because when we go through the status report or health status of a tribal women and their reproductive choices, it is a great concern that due to their lack of awareness in this field, or due to their insanitary condition, lack of use of contraceptive measures, lack of pre-medical checkups, and also lack of decision making and having an autonomy over their own body, they are being denied their rights. And it is found that there is no healthcare provider for them to see for them or to make them idea about what are the changes that have been taking place in their body, what are the gynec disorders in their body, how an abortion is to be done. So what it is being found out is that they are using illegal methods or unscientific methods for doing the abortion and all, and which finally affects not only the women's body, but also it may cause the death of both the women as well as the child. So what we can do to protect their rights? When we speak about human rights, we have to give concern about those people who are not having any idea or any awareness about their rights. But it doesn't mean that this is an end. We can make changes, we can bring forth some changes, but how we can bring forth certain changes? Actually, we know that we are living in a era where there is a three-tier system, isn't it? We brought forth 73rd and 74th Amendment, where it is said that the local self-government are having a very important role to play. Why the government should not delegate their power with regard to this for implementing certain process and programs for these people? So we have to give power to Kudumbashri. We have to give powers to the Anganwadis, Balasabhas, etc. so that there can be trained staff who can move towards them and to give them idea about their basic right, like right to health. So there should be a periodical evaluation of these women. We should go towards them because we can't come to a conclusion that they will come towards them. So we have to go towards them. We have to make them aware. We have to educate them, even though we say that the right to education is a basic human right basic fundamental right and human right, and it is guaranteed as a fundamental right under Article 21A of the Indian Constitution. Most of the tribal people are not having any basic education. So these are all I have collected from the data, and when we go into it, we can see that we have to provide them at least basic education, like what are the health issues they have to face or they are facing, so that they can come forward and they can come towards the hospitals or the health centers, which that can provide them guidance. So taking all this into matters, it is necessary that when we speak about human rights or when we speak about our fundamental rights or the law implementation or the legislative enactment, it is the need of the hour that we should protect the rights of those people who are being denied their basic rights. So I hope that Through this paper presentation, which have been put forwarded by the Global Forum as well as by the Central University of Kerala Department of Law, we can come forward with so many suggestions and ideas with regards to the human rights as well as the law implementation in this field. So thank you once again for the organizers and especially Dr. Girish Kumar, who was my friend from my LLM days, and also for Dr. Jaishankar sir, and also for all the dignitaries on and off the dais, my beloved teacher, Dr. K.C. Sanisa, and also all the paper presenters. And I hope that this paper presentation will be a fruitful one. Thank you. Thank you so much.
Thank you, ma'am. I request Dr. Sanju V K, ma'am, to speak a few words.
Thank you, respected dignitaries, my beloved friends and resource persons in this session, and dear participants. I feel greatly honored to chair the session under the effective coordination of Dr. Prakash.
Excuse me, ma'am.
Am I audible?
Yes, ma'am. Can you please switch on the camera?
See, I'm not in a position. My health issue is so deteriorating, so kindly excuse me.
Okay, ma'am.
So I feel greatly honored to chair the session under the effective coordination of Dr. Prakash sir, Dr. Girish sir, and Dr. Jaishankar sir. And first of all, let me offer my heartiest gratitude to the organizers for inviting us to this August function. And special reference may be made to Dr. Sunny sir and Krishnoma sir, my research guide, who are also present in this particular session. Now, let me move on to today's highlights of the conference on suitable strategies, measures, and solutions in an interdisciplinary conference on business management, science, technology, human rights, and contemporary legal issues and reflections among the pandemic. As we all know that the COVID-19 has severely affected individuals as well as organizations in multifaceted dimension of corporate sustainability, where there is a threat, we have a threat to social, economical, and environmental issues. And so we feel it is a need of the hour to strengthen the social responsibility of the individuals and organizations to meet the current and future expectations. This corona has resulted in the lockdown of and as well as in the strict control of domestic as well as international relations, and the global trade is expected to decline considerably. And this has also a dramatic impact on many economies and global trade to a point of near deglobalization, with almost all business activities coming to a halt. And we all know that several legal issues have sprung up, and hence there is a perennial need to meet the challenges while we do not have a comprehensive framework to meet the different challenges faced during the COVID pandemic. Now, in this scenario, there are numerous legal questions that arise, but the novelty of the issues make it totally perplexing to solve. Hence, in the light of these complexities, I feel that this conference is a welcome step. And on a perusal, it is seen that this conference will plug the loopholes in various arenas like issues in education sector, technological aspects, human rights issues, and issues in workplace, and moreover, the issues related to children. We are also the paper presenters. Myself, along with Dr. N.L. Sajigumar, has forwarded a joint paper on drug abuse among children, which sprouts bonsai culture, a socio-legal analysis. Let me have a review about that. Drug is a suicide paid in installments, as Titus Lang has observed. Drug addiction, as we all know, is often regarded as a disorder among children, may also be seen as a worldwide epidemic which regulates physiological as well as psychological behavior. Now, according to the World Health Report of 2018, it highlights the importance of the gender and age-sensitive drug policies, and it explores the particular needs and challenges of women and young people. There are, this drug abuse there are mainly three factors for this drug abuse. One can be seen at the personal level, the second one is at the micro level, and the third one is the macro level. Now, factors at the personal level may include behavioral and mental health, neurological developments, gene variations resulting from social influences. At the micro level, we have the parental and family functioning, schools and peer influences. At the macro level, there is a socio-economic and physical environment which influences them for a drug abuse. We have a plethora of international as well as national legislations which curbs the drug menace in its operation. And the first international convention, that is International Opium Convention, which is otherwise called the Hague Convention on Narcotics, was held in 1912, and which is the first drug traffic control treaty at the international level. Now, India is also a signatory to the 1961 Single Convention in Narcotic Drugs, and as amended by the 1972 Protocol. We have a convention by the United Nations in International Drug Control relating to International Conference on Drug Abuse and Illicit Trafficking held in 1987 at Vienna. The convention is primarily meant for controlling trafficking activities in narcotics at the international level. Now, in view of the alarming increase in the drug menace in India, the Parliament enacted, as we all know, the Narcotics, Drugs and Psychotropic Substances Act 1985, which was later amended in 1988, and the last being an amendment made in 2021. The penalties are from 10 years or 20 years imprisonment and a fine of ₹1 lakh or 2 lakhs. Now, the act doesn't make any difference between a drug addict and a drug trafficker in respect of punishment, except we have two sections, that is section 27 and section 64A of the act. What is section 24? Let us go through section 27 of the act, which states that if a drug addict proves that he possesses drug of less than small quantity as notified by the central government, and that it was for his own personal consumption and not for sale, he shall be liable to punishment, which may extend to 1 year. The highlight of this particular portion is that, suppose the thing is that in all other cases, there is 10 years or 20 years imprisonment, and this particular case, it is reduced to 1 year. And section 64A provides immunity to a drug addict from criminal liability, provided he proves that the offense is committed for the first time, but he voluntarily treats or consents for a de-addiction in a rehabilitative and reformative measures being taken. Now, section 31A of the NDPS Act. See, our Indian penology follows a reformative theory, but section 31A of the NDPS Act speaks about death penalty for repeated offenders. So, death penalty is also provided under NDPS Act. So, what I have to highlight is that there's the reformative theory is we have a mixture of reformative as well as deterrent theory with respect to NDPS Act. And in state of Maharashtra and others versus Nagpur distilleries, 2006, a two-judge bench of the Supreme Court took a serious note of the liquor addiction among the younger generation and urged the government towards reducing the consumption of liquor. And the apex court emphasized that Article 47 of the Constitution cast a duty upon the state to reduce the consumption of liquor. There is a dire need to evolve an effective control mechanism and for the unrestricted production of drugs and the sale in open markets. So what I have to suggest, certain suitable remedies are to be suggested. We have to early detection of drug addicts should be made out, and the prompt treatment and re-socialization may help to prevent drug abuse. Then regarding then prevention programs, then society as well as the educational institutions should take a positive step. Prevention programs should be carried out in families, schools, and immediate communities. Media, especially in the entertainment segment, also needs to understand its role in this context. Hence, it is high time that we join hands to fight against this menace. With this, I conclude, and once again express my heartiest gratitude to all the organizers for such a wonderful venture. I welcome all the participants. Thank you.